Hello and a warm welcome to Personal Finance. I'm Gugulethu Cele. Now, are you an investor who has assets offshore and ever wondered how you need to treat them should you have a will, especially based in South Africa? Well, to tell us more about this, I'm joined in studio by Judy Snyman, Trust and Fiduciary Specialist at AlphaWealth. So good to have you with us this evening.
Thank you, Gugulethu. Thanks for having me.
Awesome. I think whenever we talk about wills, people tend to shy away from the topic because no one wants to admit that fundamentally we're all going to die someday, and how you actually split your assets forms an important part of your financial planning structure. But for those who have assets offshore, is a South African will sufficient enough to take care of those assets?
Well, Gugulethu, it depends. It depends on the person, on their circumstances, and also on the type of assets they hold and where those assets are situated. So it is important that that every person assess their financial situation, speak to their wealth manager, speak to a fiduciary specialist or their lawyer, and to determine whether they need a foreign will or not.
Tell us some of the reasons why you say that. Is it because maybe there are different treatments for wills and estate duty in different jurisdictions?
Absolutely. So when it's circumstances, maybe I can use a few examples of circumstances when you would need a foreign will. Essentially, when you have assets, or I can explain why you would need a foreign will. It is when you have assets in a foreign jurisdiction, your South African will can deal with those assets. The problem that arises is that a South African executor would have to seek recognition in that jurisdiction, have to apply for probate or go through a court process to get the necessary authority for the banks and the financial institutions or the property registry to actually act on their authority. They can't, as you can imagine, you can't just show up to a foreign bank and say, I'm Judy's executor and I would like you to pay away these assets. They will require some form of formal authenticity or authentication rather to actually act on what you instruct them to do. So that process can take a bit of time.
And cost money too,
and it can cost a bit of money, exactly. Yeah. So and that can hold up the winding up of your South African estate. So it's important from that perspective to make sure that you have a foreign will where you appoint a separate executor. It can be the same person, can be a different person, but at least that process can run separate but parallel to the winding up of your South African estate. And when you have that foreign will and the South African executor or the executor is appointed under that will, there won't be quite as many formal processes to go through. There will still be, like the same as you would have to go through in South Africa, but it won't take as long or cost quite as much money.
Judy, if we take two steps back though, for the viewer who might be watching and concerned about the fact that maybe they don't have this foreign will in place, do they need to be able to distinguish which particular assets they have in different jurisdictions, like you alluded to earlier? And would these particular assets be theirs via way of inheritance? Maybe they have grandparents who stay in India or the UK or Switzerland, or even a bank account that they once opened there during their time working in a foreign jurisdiction, and they haven't necessarily closed it or wound that up just yet. Absolutely.
So again, it depends on the jurisdiction and the type of asset. So if you've got what is known here as an asset swap arrangement where you buy into a South African fund and that fund then takes that money and invests it offshore, that fund is still a South African fund and the asset is a South African asset. So if that is your only foreign asset exposure, then you wouldn't need a foreign will. If you've got a bank account in England or a property that you inherited or a share portfolio that you inherited or that you built up yourself, then you would need a foreign will, or it's advisable that you have a foreign will at very least, so that can help with the winding up of your foreign and your local estate. It is also, like I said, important that the country where it's in. Switzerland, for example, the banks and the financial institutions there are quite happy to act on the instructions of the South African executor, where that executor provides notarized copies of the will, of the letters of executorship, death certificate, all of those types of documents, they are quite happy to act on those instructions. So when your only asset is a Swiss bank account or or some Swiss shares in a Swiss company, then you generally wouldn't need a foreign will either.
I think maybe I need to pay a visit there to make things easier. But what about the person who's been a travel extraordinaire and lived in several jurisdictions and maybe has different assets allocated in different geographic locations? Would it ever be possible for them to get a generic foreign will, or do they need one in Thailand, in Switzerland, in the UK and even the US?
Yeah, so it depends on the asset. If you have immovable property in a foreign jurisdiction, it's always advisable to have a foreign will in that specific jurisdiction, because property laws are different in every jurisdiction. How it is inherited, how it is treated at death is different in every jurisdiction. So it's important to then have a specific will dealing with that property, and possibly also to consult a lawyer in that jurisdiction to advise on how the will should be drafted. But if you've got shares on exchanges in various jurisdictions, it is not necessarily necessary to have a will in each of those jurisdictions. You could get away with a generic foreign will. It might then again take a bit of time for that foreign estate to be wound up, but again, at least your South African estate won't be delayed by it. The executor under that foreign will would potentially have to go and apply for recognition in each of the jurisdictions, but so that could take a bit of time and a bit of cost, but it is it won't delay your South African estate at the very least. And what we've also found is that where you have, say, a bank account a trading bank account in the UK, as an example, where you invest through that account on various stock exchanges over the world. You might have some American stock, you might hold some Swiss assets, you might hold some French, Korean assets all across the world. The executors often treat, instead of going and applying for recognition in each of those jurisdictions, they often treat the bank account through which you trade as the asset, which is not technically correct, but it speeds things up, and it is how in practice they often do it.
A lot easier,
yes.
Versus
absolutely.
the admin and the implications thereof.
Absolutely.
But what about the tax elements? I understand in South Africa, estate duty tax is what, 20%?
20%, that's correct.
Given the fact that one might have foreign assets, would the tax implications then be a lot higher, and would they have to pay tax in the other jurisdictions too?
Yes. So as a South African tax resident, you are taxable on your worldwide assets and your worldwide income, and that's the same on death. You pay estate duty on your assets wherever they may be. So as a South African, you would have to, and you've got foreign assets, you would have to declare, or your executor would have to declare those assets in your final tax return, your estate duty tax return. So having a foreign will doesn't mean that there would be no estate duty payable in South Africa. There are circumstances where you may have to also pay estate duty or inheritance tax or death taxes in the foreign jurisdiction, but you get a credit for the duties you paid in that jurisdiction under the South African law. So you would get, whatever you paid, you would get a deduction in South Africa up to 20%. So if like in England, where inheritance tax is 40%, which is double South Africa, you can't get the full 40% deduction. You can only get a deduction up to 20%. And South Africa does have double taxation agreements, double estate duty taxation agreements in place with, I think at the moment, about 6 countries. We've got effective agreements with 6 countries. So it's not many, but those agreements will determine where the assets are taxed. So it will either say that it's taxed where the deceased, the taxpayer, was tax resident, or where the assets were situated at the time of that person's death. So that it's often the case that it says that it's taxable where in the jurisdiction where the asset is situated, and in that case you would then pay the death duties in that jurisdiction and claim an allowance in South Africa.
Judy, for someone watching and clearly having listened to all of this, they might be slightly nervous, and first question that comes to mind is, who do I speak to in order to set up a foreign will, and what are the cost implications, and do I need important documentation in order to support my foreign will?
Yes, so the person to speak to would be your wealth manager, who can point you in the direction of somebody if you have a wealth manager, or a fiduciary specialist if you know one or if you have one. Also, a lawyer should be able to do it for you, or should at least be able to refer you to a foreign lawyer if your assets are quite complicated. But so you can speak to any of those people to help you. The costs, again, would vary from person to person.
I take it based on the assets
more based on how complex the situation is. If you have to go and speak to a French lawyer about your French property, your French immovable property, the cost there could be much higher than getting just a generic will, foreign will done through your fiduciary specialist or your wealth manager or your law firm. So the cost shouldn't, if you get a generic simple one done, it shouldn't differ too significantly from the cost of a local will. So I wouldn't think, at the very least. But if your situation is more complex, if you've got to involve foreign lawyers, or if you're having multiple wills done, then it could be a bit higher. In terms of documents, to prepare the will, there's nothing really that you would need to prepare the will. Just the usual full names, ID numbers, that sort of thing, children's names, your heirs' names, who you want to leave it to, who you want to be the executor, that sort of general will information. But it is always important to let your family know, your wife or your husband, or keep a little file at the very least of what your assets are, where they are, so that when you die, your executor doesn't miss any of the assets.
Yeah.
I mean, it happens so often that 5 years down the line, you discover, oh my goodness, this person had some shares in that company, and everybody missed it.
Sure.
So it's important to keep a little file, or at least keep a list, or make sure your wife or your husband or your children, if they're grown up, knows where your assets are. And it's not a bad idea to keep that in a file with your original will, somewhere in a safe place.
Judy, we've said quite a bit, but if we wrap up tonight's conversation, the key takeaway points that you want the viewers to remember tonight.
So the key takeaway for me is to know what foreign assets you have, and to know where they are, and that you may need a foreign will in certain circumstances. To go speak to your fiduciary specialist or your wealth manager, who can help you prepare one if you need one.
Seek advice. Judy, thank you so much for your time. Great insights that you shared with us today on the importance of having a foreign will should you have foreign assets. A big thank you once more to Judy Snyman, Trust and Fiduciary Specialist at AlphaWealth. Get in touch with us and share your views with us. You can tweet us at CNBC Africa using the hashtag Finance410, or to myself at Gugulethu on Twitter. Until next time, take care everyone.